Hello, my realtors family. Good afternoon. And we are here once again for our KRAB Hour of Power. And today, I'm sorry, you guys, my name is Robert Johansson. I am your third VP of KRAB over education. And every second and fourth Wednesday of the month, right now, we have our Hour of Power. And twice a month, you guys, we bring you guys resources that can help you guys to build your business. Okay. And we have a very, very special guest speaker. We have family in the house because he is actually one of our KRAB directors. And I have to say this, you guys, I could not do this hour of power without him because you guys, he is such. I mean, Mike, you are such a resource. It is just unbelievable.
I
Anything
ghosted you last month, though. I feel
want
real
to know in
bad.
real estate, just call Mike. Just call Mike, and he will have somebody in that area to present.
I do feel bad, though. Like I said, I totally ghosted her the last month because I've had some other stuff going on, and I'm like, I can't do anything right now. So I
No,
feel
I appreciate you totally. So I am very honored, you guys, to have our guest speaker today. Once again, you guys, our KRAP director, and Mike is going to go over you guys some of the updates to the contracts. And I must say, Mike, you must be popular because for the first time ever, people was joining on before early. I was like, they got on before me. I was just like, what are people doing over here already? So it must be a very important topic, which it is, for everybody to hear about. So I'm going to hand it
it's
over to our
not.
guest speaker. Mike, it's
Every-
all yours.
Everybody's just home today. That's what it
Is
is.
that what it is?
Everybody's just home. It's summer. If your kids are like my daughter, who's now 14, she just turned 14, she doesn't hang out with me anymore. She literally just spends all the time with her friends. So I'm just like, guess I'm working. I mean, that's how that works. So good morning, everybody. Or actually, it's good afternoon. And thank you for spending time away from the 24-hour news cycle to pay attention to this stuff because I try to be more positive. So, as Yvette eloquently said, my name is Mike Shankman. I am honored to be a realtist as well. By the way, what time is it?
It's a great time to be a realtor.
Exactly. I look forward to seeing a bunch of people in a couple weeks up in LA. But I'm also a director for CAR as well as I'm a certified forms instructor for CAR and an instructor here at UC San Diego down in San Diego. I do a lot of these trainings, and obviously there's a lot of forms we need to know because by knowing the forms, we know exactly what's already pre-built and incorporated in for us. And I will give you a quick example of how important it is to know these. So I just had to close at one of my agents. This is why I got sidetracked. One of my agents called as soon as I was done with I was teaching fair housing and that ended at 11. My agent's blowing up my phone because one day before the close of escrow, which is today, and close of escrow is tomorrow, the condo flooded. And we get all this stuff, and the seller or the buyer is like, okay, well, give us 15 grand or we're canceling. And I'm like, okay, well, let's have a conversation. Based on what's in the forms and the VP and all that, the other agent backed down. It's up in LA. Knowing your forms is what helps you get through everything. And so I'm going to go right into it and just let you guys know. Now, here's the stuff you guys hear. We had 95 total form updates, right? And that looks a little daunting. We're like, oh my God, so I got to learn 95 forms. Well, of those 95 forms, we had 11 new forms, brand new that were incorporated. You want to know how new forms always work, by the way? Go and see what the lawsuits were the immediate time before. And then from in addition to that 95, we've got, or in that 95, 32 substantial revisions, 52 form revisions, and 4 forms that were just outright removed. You see, here's the thing. We do updates twice a year. We being CAR, right? At the end of the year and in the mid-year. End of the year is usually the big one. We've got that coming up in December. But then in June, we do a mid-year update, which is like, hey, there's some stuff that's happening, and let's be real. There's a lot of change that we've been seeing, a lot of things that have been corrected, a lot of things that need some adjustment to it. And if you look at what happened, a year ago, we thought the sky was falling, and they came up with these changes to our commission structure. Well, as you do that, those who sat in on the commission change instruction I did last year and at the beginning of the year, I had said we're probably going to see some changes to these forms because we're testing them. As they come out, we say, oh, this works. Oh, this doesn't. Oh, someone sued based on this. And that's what standard forms all does, right? So of our 11, sorry, that's Harley. She has to get involved in anything I do. So it's my daughter's cat, which means it's my cat. Here's our new forms. And I know this seems like a pretty exhaustive list, but if I do this, it kind of shows you how the breakdown goes of what's brand new. We have these transactional forms. We have now set up something to where there's an addendum and an amendment. So we've always had this, but there's a difference between when we do an addendum and when we amend something. And I'll get into that. I'll show you that at the end. A lot of times, like I am the king of that. I love using the form AD, right? Why? Because I like to just use it as a catch-all and use an extra form. That's actually incorrect. So I'll show you when we're supposed to do that. We have our new construction advisory, the confidentiality non-disclosure agreement, rental property owner advisory, the seller in possession, and the short sale listing addendum. If we look, we can start to see what's important right now, where we're needing some changes or something specific. Back when I started in real estate, I used to say, too many damn forms. And after I was broker of record for a while and I started realizing this and doing this over the last 20 something years, I was like, wow, give me more forms, give me more protection that I can give to my client to say, hey, write this out and instruct them. You'll see we have short sales on there again. We're like, really? Well, when things go up, they have to go down. We're anticipating some rise in short sales. The average first-time home buyer was putting about 3 to 5% down. When you have a massive increase in appreciation and then a drop that gets rid of it, you're going to have a short sale if someone's in distress. We have our property management forms, our move-in inspection advisories, the summaries that go with that, the pre-move out inspection, and the short-term vacation rental advisory. And then we have a team member exit agreement. I will go over the majority of these. Now, moving on to our substantial revisions. These are forms, and this isn't the entire list. This is just some I thought should get pointed out to you. These are ones that had somewhat of a larger update. Usually it's some language that was removed, language that was added, maybe a term that was put in. And that's usually forms like the RPA, the RLA, our buyer representation. All these three core ones are getting changed probably every time right now. Because as we make changes to the commission structure and see what worked and didn't work, there has to be synonymous language between them all because they tie together. Remember, our RPA is what ties together our RLA and our BRBC because that's our representation of the two clients. You have to make sure they tie together. We've changed the addendums, cancellation, seller contingency removal, forms like the lead-based paint, notice of broker-involved properties, the probate advisory, short sale addendums. All these things have been updated over just minor updates that come in. We have our 52 form revisions. That's why I was laughing with that 92 changes. You don't have to worry about those. You basically need to focus on the 11 new forms, our substantial revisions. I'll give you a list of everything, so I'm not going to go over all of them. I'm going to go over the most important ones today. But usually those are forms that no new education is needed. Every 4 years, most people don't realize there's a form update. You look at them, like all forms have to be reviewed at minimum every 4 years. And sometimes it's just, no change the date, stamp it, it's clear. And that's to make sure that things are keeping up to date with what the laws are. We don't want to violate them. And are we attorneys? Even if you're an attorney, are you an attorney right now? No, you're a realtor or a realtist. Okay, you are not in the capacity of being an attorney. You should not be giving legal advice. You should not be redlining your contracts. I've seen people do. I saw someone do that about 3 weeks ago. I was like, stop doing that. Okay, we're not lawyers. We are facilitating this. 7 conform purchase agreements, 4 conform listing agreements. We have changes to the service providers. Signature blocks were updated. They changed the order of representative capacity and things like that. The removal of the property address and initials from some advisories. Just making them simpler, streamlining it. Like we don't need to have this stuff here. We did make some changes, which I'll show you to the AOA, which is the assignment or the addition of agents. And I'll show you why we have those changes in there. Sometimes there's no change at all. Like I said, just the way it is. And then there's sometimes we just don't need a form anymore. So we get rid of it. That's it. So remember a year ago, did we think the sky was going to fall? How many people heard the sky was going to fall or acted like it or had a realtor that was like, it's done? Or have you scrolled through Insta or Facebook or anything? And it's one of those things where it's like, buyer's agency is dead. It's all AI. You should all run for the hills. Or some of those people, I think I put in one. I go, well, just get used to saying, hi, my name is Steve. Welcome to my Uber. I mean, if that's what you really want to do, but we make changes. We adapt. And I don't know about you. It's almost been exactly 1 year. August 17 marks 1 year since those changes came in from the settlement. I haven't seen much of a change. I've seen the market change. I've seen homes sitting longer now because of different conditions, but I haven't seen a change in compensation and I haven't seen a lot of pushback on certain things. I have seen agents leave because they don't know how to explain value. That's what I've seen. So, it's how we look at it through that prism. So we have seen certain things change in our market. This is Wall Street Journal. Just about 3 weeks ago, I pulled this up. Home sellers outnumbered buyers by nearly 500,000, right? Which is telling us we're going into a shifting market. If you're not focusing on your buyers, you're missing something because that's what happens when the market shifts. And that's what we're seeing right now. This is summer. We're seeing slowdowns. So I don't want to make too much about it, but you're going to see how the forms have gone to reflect this. And also, if you want to anticipate the future, we're going to see some other changes, I think, in buyer representation and how buyer forms are come December. So let's look at the RPA, the residential purchase agreement, which is the core of everything we do. By the way, if I go too fast, someone stop me. D, don't fall asleep on me. So you think I was going to call you out, but see, now I'm yawning. Oh, see, there we go. So remember 3G3? We all know that one, right? I think every single agent, it's funny. They might not know their damn contract, but they know what 3G3 is because it's how they get paid in an offer. So 3G3 has seen the majority of changes. And remember, G in general talks about seller payment to cover buyer expenses and costs. Okay, they reworded that a little bit. This was the red line from December. And we look at credit to buyer, additional credit terms, but 3G3 talks about our compensation, and it's optional compensation. Why do I say that? Does the buyer have to include the payment of commission in the offer to the seller? Do they have to? Anyone? D, I'm going to pick on you and make sure you're awake. Do they have to? Nope. There we go. See? They don't have to. You can choose to. They can choose not to. And that's why it's make sure it's very. Why am I saying that? Because we have had reports of agents telling, and they report you, they do it, they bring it up, saying, well, we have to include it in the offer to purchase here. Well, they don't have to do anything. So the buyers, everything is optional to them. Now, if the buyer doesn't have the money to pay you, do they have to have the necessity to include it? Yeah, or they don't buy a home. That's a little different. It's still, they don't have to include anything inside their offer. Whoops, click the button here. So what was removed? You see, you remember we had this whole thing where they went through these changes. And it was 2 years ago. Can you guys hear me okay if I'm sitting back here? Is that okay? Okay, I was always worried about my microphone. So 2 years ago, we made all these changes. And CAR was very forward thinking. What did they say? They said, look, we're going to see a time where we're going to have these buyer representation agreements, and we're going to include for compensation on there. So you had to do the SPBB, right? Which was a seller payment to buyer broker. Basically saying, hey, if I'm at Yvette and I go, hey, Yvette, I have a client. My client has agreed to pay me X amount of money, and I am now asking for that money in here. And this form certifies that I have that buyer representation agreement, right? Well, at that time, it wasn't required. You didn't have to have it. By the way, is it by law that we have the buyer representation agreement? And here's an open question. By law, when do I have to have the buyer representation agreement signed? I can't hear you, D.
Before you take them out.
Before you take them out to see the property? Okay, how many people agree with that? By law, that is incorrect. It is and no, I did that on purpose.
That's my law.
That's your law. No, well, actually, you have to follow it, but it's not the law. AB 2992 was passed in January or went into effect January 1, and I'm bringing this up because people keep confusing this. I might have a slide. If I do, I'll skip through it. It was passed in passed last year, signed in October or November roughly, and signed into law and took effect on January 1 of this year. That says by the state law, you have to have a buyer representation agreement done as soon as practical before the offer is made. Now, we have the settlement. The settlement says you need to, and created a standard of practice that has to be followed if you're an MLS member that says, guess what? I will show, let me make sure I don't have it in here. I will have a representation agreement signed with compensation in all terms before I show the home. Now, what's the difference? I always use this example, like, not to bring up religion, I'm Catholic. You ever hear the expression, all Catholics are Christians, not all Christians are Catholics, right? Same thing in real estate. All realtors are real estate agents, but not all real estate agents are realtors. What is a realtor? A realtor is a member of NAR. They ascribe to the Code of Ethics. And they are MLS members too, right? That's how you get your MLS membership. You pay your dues, but you have to be a member of an association. If I'm a member of a local association, I'm a member of a state association, I'm a member of the National Association. The National Association has made a settlement. In the terms of that settlement, they have said, you will do this. That is what the settlement says. Now, maybe I'm an agent here in California and I'm not a realtor. Maybe it's my neighbor. My neighbor holds a real estate license. Can my neighbor help facilitate me to buy a home? Absolutely. They don't have to be a member of the MLS. They don't have to be a member of a lot of things. They can do real estate services for a fee. So that is the difference between the two. Always know that. Now, are you all MLS subscribers? I would hope so. If you're a producing agent, you need to assume you are. Follow the settlement. But don't ever tell someone it's the law, I do it before. I mean, it is the law, but it says a different deadline. And I say that more so that we all know if you are an MLS member, because that's what it comes down to. If you're an MLS subscriber, you have to do it before you show a property. That's all. Okay. So if someone says, oh, I don't have to do it before until I make an offer. Well, that's law. Are you an MLS subscriber? Yeah. Then you got to do it. It also said you can't make more than what's in your buyer representation. And it said a few things, but now it is the law. Everybody's covered. The realtors are covered and the real estate agents are covered. So because everybody has to do this, we have to have a representation agreement. It says right here, all this was stricken because remember at the beginning of the year, they said no more SPVB. We have what's called a buyer compensation affirmation. And it said the buyer affirmatively represents. And what's happening is we're getting a little too much in the legalese. Okay. Realtors are becoming attorneys. We don't need that. So it was, look, stop making realtors be attorneys because now they're interpreting things. Now they're saying this is the law, this is that, this is this. You're saying under penalty of perjury. No, I don't see penalty of perjury anywhere on here. So you're like, you know what? Get rid of it. Because here's the thing. If the buyer's filling it out, the buyer's acting honestly. If the agent's presenting it, the agent needs to be acting honestly. And if the agent lies about compensation in here, you know what they violated? The law, because they violated the statute of frauds. That's where that comes in. So like, get rid of it. They remove the affirmative representation. Now, do you have to give your BRBC to a listing agent if they request it? Do you? What do you think? You're not in trouble if you give an answer. A lot of people think they are. And here's the thing, CAR, nor is there any law that says you have to turn over that BRBC. Now, as an act of good practice, though, if D is my listing agent or the listing agent on the property, do I want to tick her off? Do I want bad blood? I want a smooth transaction. So I can choose to give her a document. What I like to do, I like to give the 5th page, the last page that says buyer representation. It has a compensation number on it. Because there could be terms in the full BRBC that I don't want them to see. And I don't think that's nothing wrong with keeping that confidential. But you could say, I don't have an obligation to. In the offer, it does say that escrow can request it. So that's to let you know, okay? Or that escrow will receive it in escrow. It doesn't say anything about the listing agent getting it, and there's no stance on that as far as the associations go. So you will see they've added language. They struck that one language and they've added this. The amount of compensation, if a percentage, will be based on the final purchase price. Buyers advise that buyer's broker should not receive compensation from any source in excess of the amount in the buyer representation agreement. Why do they have this? Because agents are doing it all over the place. They have a BRBC at 2% and they're asking for 3.5%. You know, can't do that. That is a violation. That's a big no-no. Okay, if you want to get paid 3% because that's what you're going to charge your buyer, then that's what you need to put in there, and that's the max you can ask for. Also, if I have 3% in my buyer representation agreement, do I have to ask for 3% in the offer? No, I could ask for 1% because that's what my client wants to do because it is a term of the offer. And that's what we're trying to really point this out to everybody. So, and we're seeing a lot of issues with this violation on here. There are other supporting documents that bring this up. I'm going to go through these a little faster. The BRBC in 4G3 says right there, under a settlement agreement, not under the law, under a settlement agreement. And I say that because I'm going to tangent for 1 second. A lot of realtors say this is the law, and you shouldn't do that. Like for a lot of things. There's only a few things in real estate that really are the law. Otherwise, they're contractual terms, and that's different. A law means there's a statute. And if I violate that, I might be in trouble and go to jail or have to pay a fine or do all this other stuff. Versus if I breach a contractual term, well, I could have damages with the deposit or whatever. You see, there's a big distinction there. So we want to make sure we're clear of what's part of a settlement agreement and a policy that we need to follow that can have repercussions for us as agents, and what's part of the law that can affect our licensing and affect our freedom, you know, and our the way we do things and make us subject to lawsuits. So that's why I'm very clear about this. So it says under a settlement agreement binding on realtors, the broker is prohibited from receiving compensation in excess of the amount of this agreement. In the BCA, it says seller pays compensation pursuant to an NAR settlement. Buyer's broker is not permitted to receive compensation for services from whatever source that is greater than the amount that's on there. And then in the listing agreement, it says that seller should agree to do so. Broker does not represent, nor will broker confirm that the amount specified is owed to a buyer or buyer broker is pursuant to a written agreement. Same thing down here in the seller advisory. It says, should the seller agree to do so? There's no requirement for them to pay that. It's a term of the offer. So these are the changes we've been seeing. Okay. Does that make sense? Any questions about it? Cool. I'm going to move on. So home hardening. Who loves home hardening laws? Who totally understands the home hardening disclosure? I think that's like the most confused form in history with us right now. I don't think I've ever had more questions in my life than trying to understand who does home hardening and when do we have to fill it out. Something very specific. Let's define home hardening because we've had some insurance issues in California, haven't we? Just a few. And we have them all over the country. I don't know if anybody has family in Texas. I actually do have some friends and family that are in Texas, and that's been breaking my heart because, especially when you think things might be avoidable. I'm not trying to give any political thing. I'm saying honestly, I think any death from a disaster is avoidable when we think about it, and it's unfortunate. So, home hardening, the process of increasing its resistance to a wildfire within a home ignition zone. So, what is the home ignition zone? The home ignition zone is an area within 100 to 200 feet of any structures and vegetation around the property or found on the property. So this started, believe it or not, I remember first going over home hardening around 2018. And this is when they were saying, okay, look, we're going to have an issue here. What's going on? How can we protect the property? And there are certain improvements that have to be made, and there's like ice plants, there's all sorts of things that can do some sort of fire retarding on the property to keep it away. There's these certain zones around. Most people don't realize that there were things in the disclosures that took effect this year. So July 1 of 2025, just a few weeks ago, we have the seller must advise what fire hardening has been completed during home ownership. Now, you see, here's the thing. Is that saying they have to advise what's there? It's like when I teach my licensing classes to people, I always say, don't take outside information in. Look at what it is confined within the document. It is very specific here. Seller must advise what fire hardening has been completed during home ownership. So we have to tell them what you've done. So if Marissa, you're the first one here, and I see a 700 plus next to you. That's very exciting. So if I have Marissa, who is my homeowner, and my homeowner or my seller, and I didn't ask her if she knows of any fire plants or ice plants, or roof retrofits or anything. I'm asking her, did you put them in during your home ownership? See the difference? That's what they're asking. And that's what your seller is going to complete, not you. When your seller asks you to complete these forms, you say hell no, because you will get sued and they will win and you will lose a lot of money. And when you call me, I'm going to say call an attorney and make sure it's a real estate one and get your broker on the phone. Okay, that is part of the law. Some of these disclosures are covered by statute that they need to be completed by the seller and the seller alone. The seller doesn't know the answer. You know what they say? I don't know. And that's an honest, truthful answer. I don't know. That means do your due diligence because I have no knowledge. The only thing that they need to do is be honest about it. So we're going to go over these real quick. Law of applicability, built on or after January 1 of 2010. Most people don't realize that if the property is built on or after January 1 of 2010, they do not have to complete 2B and 2C. They don't have to do it because the retrofits are already a part of it. These mitigation measures are in the code and the construction standards. So the first thing, check the box. Okay, done. End of story. So, and I recommend, I'm not going to go to the full FHDS. I recommend, if you don't know this form, please review it and please review it with your broker. Okay? Because this is given to your seller. It doesn't say they have to do stuff. It says, what do they have knowledge of? It's when they say, oh, my seller has to do all these fire mitigation measures. I'm not going to speak for your municipality throughout the state. I am going to say that we give these as advisories. They're completed as disclosures and they're done. So fire hardening vulnerabilities. Are you the seller? This is B1. This is the first part. Aware of the following features that make the home vulnerable to wildfire and flying embers. It does say seller is not obligated to explain or clarify their responses. They are allowed to give a voluntary explanation. Why is that? If you look at the SPQ or TDS, every time the seller answers yes to something, what do they need to do? Explain it. Here they don't. Are you aware? Are there roof coverings made of untreated wood or shingles? Yes or no? And they can handwrite in there sometimes. They could say no, and then explanation or clarification. B2, not aware if it is. I think it might be, but I'm not sure. I always tell my clients the same thing. Be honest. I have sat in court hearings. I have given testimony. I've done all sorts of things, to explain the process. And I've been asked by attorneys in certain situations in front of a judge, what do you do when a seller doesn't know the answer? And I go, you tell them to tell the truth and say, I don't know. And they did that here. I pointed at it. I go, that's what they were doing there. And now it's on the buyer. So, but it's very clear that if I answer yes, I do not have to give an explanation. Okay. Or no, I don't have to. That's just for this. Okay. Now, here we go. Have you, the seller, completed any of the following low-cost retrofits during the time you own the property? Not do you have knowledge of it, it's did you complete it? Yes or no? Very simple. And when they say, you notice, have you done it? Not necessarily, are you aware of it? Very clear. Okay. And this is part of that legal requirement that says as of July 1st, it's going to happen. You'll notice there is a link right here. And when you click on that link, it shows you what is a low-cost retrofit. So this client's not asking you because they shouldn't ask you. And if they do ask you, you know what you should do? I always say I am the laziest realtor in California. I will defer all over the place, man. Maybe it's because I was married. I learned how to defer. I don't know. I just say, ask someone else. Let's do it this way. And if I can send information from another source, and if it's a government source, even better. I just forward it and I do it in writing. You know why? In an email, because I have a written record that I am not the professional on this. However, I do know where you can get clarification on whether or not that is the answer you're looking for. See what I mean? And then when I'm questioned later, I can say, no, here's the email. I'm lazy. I don't like to do that stuff myself. So I bring it up. So that is what home hardening is. And you can see it right there, fire.ca.gov/home hardening. It talks all about it. I recommend you do it. If you do your own disclosures, you send those in. I also recommend if you don't, give it to your TC and say, please include this in the disclosure with this link, please. Make sure it's in a separate page. If you have any questions about the home hardening, please just click this link. It'll give you all the information you need. Okay? And that way you're not on the hook. Kind of fun. So any questions about that? See how easy that was? How many people understand home hardening now? See, there you go. Guys spent a few years not knowing it. Now you do. Dee's excited as hell. So when I look at the possible representation of more than one buyer or seller, the PRBS, this is one of my favorite forms to use only because it does disclose a lot of information. Funny thing is, the call that I'm getting right now is a seller for one of my agents. And the agent on here is a long story. They were going to do a dual representation thing. They had an agent in my office who was going to put an offer in for a client that had come in. And so she did the open house, and that's how it worked. Now, that's dual agency, right? We know that. That's under the same brokerage. And she goes, well, the seller's having us a hard time. We haven't submitted the offer yet because we need to redisclose agency and all this stuff. I go, whoa, 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 whoa. What are you talking about? You need to redisclose what? Well, we need him to sign off that he's okay with us, representing the seller or the buyer. And I go, what are you doing? You already did that. They go, what do you mean? I go, it's in your PRBS, which is prepackaged with your listing agreement. And it's in the verbiage of the listing agreement too. It says we could represent the seller or the buyer, and we could represent them under the same brokerage. And they give us that consent. Now they redid the form here. It looks like a lot of red because it is, but they reworded it. That's it. Because what does the possible representation say? It says, I might represent a buyer as your listing agent. It also says that maybe Marissa works for my company and we're under the same brokerage. So it's possible she could be the other agent and we could have a same brokerage dual representation. But it's possible that I've never even met her before. Maybe I have met her. Maybe my broker doesn't even know she's there. She's been dealing with the office manager all the time. We don't know. And it lists off these possibilities. It also says that as a buyer or as a seller, I might have other properties in your neighborhood under other agents. And that could create some competition to your property. It doesn't mean we're using it for anything other than what we should be doing in our fiduciary duty. And that's the nice thing about it. And it became very clear on here because it didn't used to have this section where it says dual agency. What is a brokerage dual agency? That's if one associate licensee is working with another, is working with the seller the same, the broker is considered a dual agent with fiduciary duties to both buyer and seller. Each individual licensee is also considered a dual agent having the same knowledge and responsibility. And then we have single agent dual agency, and it's a little more clarification. There is no one approach to this situation. Some brokerages allow it, some don't. Some say get someone to step in, some have the broker step in and represent. It doesn't matter. All it says is that we have these possibilities and we want to make sure that you're involved and that the office manager or someone gets involved so there's no dispute. Okay, that's all. It's covering its butt. Because if you scroll all the way down, it says acknowledgement and consent. Offers are not necessarily confidential. We might have multiple buyers or sellers, and it says what happens when you have dual agency in a transaction. So the most important part, by signing this, each has read, understands, and agrees to its terms and consents. That's the beauty of that. I love this form. I'm a dork. I love this form. I love forms like this because it tells them. And if they go to court, you know what's going to happen? Most likely the judge is going to look at it and say, well, I didn't say they could do that. Really? Because it says right there, you consent. Well, I didn't read that. Well, maybe you should start reading stuff. because it's a separate document. So, but that's what the possible representation does. It just clarifies it for you and it clarifies it for them. And then you guys can make decisions. Look, whether or not you personally should do a dual agency, that is your choice. Okay. But I will tell you, I was asked once when I was interviewed to be the broker of record for KW, which I did take the role, but they had asked because they were all from Texas. They're like, "What are your thoughts? Do you trust your agents to do dual agency?" You know what I said to them? If I don't trust an agent to be a single agent, I don't trust an agent to be a dual agent. My trust doesn't stop, with that. Now you have to make that own decision yourself. Am I okay doing this, or do I feel it'll be too much of a conflict? And you make some decisions on that. But that's not what this does. This is just simply getting their consent. We have the additional signature addendum, which is the ASA. This is when I told you. Now, what if I have, say, Marissa and Dee wanting to buy a property together, and then Yvette wants to jump into that? Okay, there's only technically spots for 2 people. So I would have an additional signature addendum. And the way it was before is we would just have the ASA and we would have it in. Now, it's very important. People don't realize certain things. This is an addendum to a contract. It's not an assignment. It's saying we have another signer. We have another person. Now, why do I not want to do a standard addendum? For several reasons. So the way this is set up here is I'm signing. So say Yvette's the additional signer. It's in perpetuity. It's at the time of, right? Or it's any addendum that adds them in. And it's saying she's an additional signer. She's also initialing and signing the liquidated damage. You see, the previous didn't have that. We realized, oh, crud. Liquidated damages in arbitration have to be individually initialed to be effective. So say Marissa and Dee signed the arbitration agreement or the liquidated damage agreement, and Yvette never did, it doesn't exist. So you may make sure everybody does it. So that's why if you have an additional signer, they have to sign this form too. I recommend having them sign the contract manually, but just put their signature on there, whatever you need to do. But you can do, the cleaner version is to do this. Now you have 2 forms, the ASA and CAR form LDAA, which is the liquidated damage and arbitration additional signature addendum. I know it's a mouthful. It's been there for a while. It's a new form. And here it is, additional signatory should only initial. So here's the deal. The only person that will initial and sign this would be Yvette. The only person. And it'll get attached to the contract. Talks about arbitration, has a separate additional initial, and then she would sign at the bottom. You see here by signing below, this is how they add. It says, for example, if X, Y, and Z are all buyers, X and Y previously signed the documents, only Z needs to sign this below, which will acknowledge them. It's just meant to make it simpler for everybody. It says we have an additional signature requirement. And you can use it for the RPA, the RLA, the BRBC, or other forms, rental forms, disclosure forms. Maybe the buyer has an additional signer for something, I'm sorry, not the buyer. Maybe the seller has for their disclosures. So they have some form of change that comes in. They need to have that signed off to add someone in as disclosing. So that's where it would be. So now we're gonna get a little education here on definitions. What's an addendum versus what's an amendment? And let me see. I had a question here. I like the addition of other properties in the neighborhood. Oh, good. Okay. I just saw that, Maureen. Sorry. Okay. What's an addendum? An addition to a finished document, such as a contract, like what we just looked at. That's an addendum. That means Marissa and Dee are signing this, and they need a space to add a third person at the time of, in perpetuity to it, okay? In the actual time frame. What's an amendment? An amendment is a formal or official change to the document. It means we are correcting or changing it. We're saying something else needs to occur here. And we see that a lot. We've seen the addendum used a lot more than the amendment. And is it going to kill your deal? No, but I have ADD. It drives me nuts. Or OCD, I'm sorry, it drives me nuts. And I actually do, so no one can say I don't. I actually do have that. Here's an addendum, and what they did was they made multiple addendums to make your life easy. We have CAR Form 80M. This is the one we've all known for years. This has been revised. It has been revised to include the term housing provider. It also says this is to be used in buyer, seller, or tenant housing provider transactions. It says if there's a change to any or addition to any previously provided SPQ, they ask that you do that on an amendment, okay? Not an addendum. So we have those forms. It's an amendment to a prior disclosure, which I'll show you separately, because there could be some cancellation rights that are associated with it. So here's the biggest thing I want you to get from this. Review them ADM, that's an amendment. I do it at the time of. So if I'm adding in some terms to my repair request, ADM 1, it would be this is an addendum to the repair request dated blah, 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 end of story, right? Or if it's an addendum to the purchase agreement or the lease or month to month, it's here. Very straightforward. We've all done it. Now, amendment of existing agreement terms. This is maybe if I'm making a change to the contract. So say, what's a good example here? I mean, it could be a bunch of things. Let's say any type of, I'm trying to think what term, maybe in theory, I'm changing my contingency dates. It could be amendment of existing agreement terms. Contingency to be extended to this date. Now, I know in reality we would use an extension. But just to give an example, something after the contract has been agreed to, some form of an amendment, okay? And existing terms. So we have an amendment to prior disclosure. Now, let's say that Marissa's my seller and Marissa has filled out her SPQ. And in the SPQ or TDS, and I've reviewed it as her agent because I should look it over. And she has checked she hasn't done any paint in the last 12 months. And I was physically there 3 weeks before and I saw that house getting painted. Well, oops. She's like, oh, I wasn't thinking. I need to change that. Just give me the document. I'll redo it. Once the seller completes that document, it's part of the record. Okay, we always want to keep it. And she would just do an amendment. You would say, seller makes the following disclosure, if applicable, disclosure applies to paragraph, whatever. And you would simply say, error made, property was painted 3 weeks prior or something. And that's it. You've amended it and then get it signed by everyone, send it over. Because you want to keep things in a line. You could also redo another SPQ or TDS. You don't have to, though. It's kind of exhausting. I've seen a lot of ways that people do this, but what you don't want to do is say, oh, no, get rid of that previous document. We'll just change it. Don't do that. Okay, do an amendment, keep the paper trail. That's what saves your butt. Making sure we have that done. Now it says right here, buyer seller receives the form. It also says an amendment to the SPQ or TDS may give the buyer a statutory contractual right to rescind or cancel. Usually it's about 5 days. Okay, if I make a change, it's a new disclosure. That's a material fact. So that's where that comes in. Then we have our generic addendum. That's just this. That's any type of addendum, like any type of changes to the contract or to any type of agreement, or there are specifics for the listing. And here's the deal. If I use the wrong form for something, it's not that big of a deal. The intent is what's there. But this just helps you be a little more professional and keep the stuff in line. Just always keep your numbers straight on this stuff, and that's all it is. That's why they put this out. It's trying to make the files easier to sort through. And I will say, as someone who's had to do compliance review, when you're looking at 20 addendums, it's like, wow, which is the one that applies here? And it can get complicated, especially for your big property sales. So referral fee agreement, they had to make some changes to this. You know why? Because it was confusing as hell. How many people put the wrong people in the wrong space? I put the recipient broker as the referring broker or whatever, because I'm like, I don't know who the hell it is. So this is one of my absolute favorite changes. You know why? Because it says, hold on. Oh, whoops. Right there. Referring broker, in parentheses, the broker getting paid for referring a client. And below that, representing broker, the broker paying the fee and representing the principal. End of story. There is no ambiguity there. And I am guilty of it too. So anyone who says I didn't screw that up is lying. So they have made this very clear for you now, and it says recipient, representing agent, and then you say, what's a representing agent? Right above you, the one paying the fee and representing the principal. And then here's the agreement, which I recommend you guys look through on your own and just see the referral period, timing of compensation, and all of that. Okay. So here's our rental property. We have a couple advisories. Rental property owner advisory. So how many times you had a client buy a rental property and they don't know what the heck the laws are? They don't know anything about it. Should you be the one to tell them? No. You should not. Because if you do, now you're putting yourself in a bad spot. And that's just the truth. I've done property management for over 20 years. When people buy properties, I am very specific about certain things, but I love this. And this is new because it does say all these things. It talks about disclosure, security deposits, screening fees, tenant rental payment. How complicated is property management in California? It is extremely complicated. And there are so many laws. Like we have AB 1482. And then that's a state law. And then like here in San Diego, we have rent control laws here. And then we have overlapping laws in Chula Vista. If I go into LA, there's laws. There's all sorts of overlapping laws which say how you can remove a tenant, but it's not just that. It may not apply or it may apply in this instance. There's all sorts of stuff that goes with that. What happens is when the client doesn't understand that, they turn around and say, my agent didn't tell me. And now you're on the hook. And you might not be wrong, but that attorney will drag you through the mud in your brokerage in order to get your E&O insurance and say you screwed up. And it's not really your fault, but we have to be clear about this. So if you have someone buying a rental property, you need to make sure they get this owner advisory, which says assistance animals and pets, notices, insurance, fair housing. What about declared emergencies when there's moratoriums that say you can't evict people or change rent? Wood balcony inspections, legal and tax consequences, and how you terminate an agency. It says all this stuff. And it's all there in a nice form. So we have the seller in possession advisory. This is a big one that I'm very glad they incorporated this in, which is how many people realize back on the tenancy thing. So how many people have had a seller stay in possession of the property? Stay like a few weeks, right? Work out a rent back, do whatever they need to do. So that's fine and dandy and good. Yes, I said dandy. I did that. See Yvette laughing. A lot of people don't realize though, 29 days or less is a different type of removal from the property. It's a different violation. It's a holdover. I'm violating the initial purchase contract. I'm not vacating the terms we agreed to. Totally different thing. You see, if I go past that 29 days, it turns into a tenancy. That's why we use the SIP at 29 days or less, and we use the RLAS, which is a residential lease after sale. The SIP is 2 forms or 2 pages. The RLAS is like 20. You know why? Because it's a freaking lease agreement. And you are now subject to that. So let's play this out. Let's say that I'm going to pick on Lorraine because she's right in front of me here, but her camera's off. Let's say Lorraine is a seller of the property and she stays in longer than 30 days and says, I'm not leaving. And the buyer can't take possession. And the buyer's mortgage says they're supposed to take possession within 60 days or they're in breach of their agreement. Now we've opened up a Pandora's box. So there's all these things that can result from that. So we just let the seller know, by the way, if you're going to stay in possession or the buyer, we say, hey, here's the things that could happen. You're giving permission. And if they stay in possession, this could happen. Negotiating terms, timing, lender issues, security for damages, final verification of condition. What do you do at move in, move out? What do you do for insurance liability? Because guess what? They're there a long time. They're a tenant. You got to change your insurance coverage, right? There's all sorts of stuff that comes with it. And termination of agency. And the last thing is short-term vacation rental advisory forms. Short-term rentals can make a lot of money and they can also be the biggest headache of your life. We also have a lot of changing laws for this. If I buy a property and my intent is for it to be a short-term rental, and then the municipality says, guess what? No short-term rental, sorry. What are they going to do? And it says, look, there could be restrictions. There could be various restrictions. There could be laws that we don't know about. You need to do your homework and diligence on this. It says that there's property owner investigation. By the way, this is the whole form. Right there. So that's all of it. It says, hey, we're your brokers. Agents have not and will not investigate or verify your information. It says it right here. You are on your own because it is very litigious. And you might have to shift from a short-term to a long-term rental. You might have to resell it then. It's not our fault. You're doing that on your own, but it's not on us because there's just too many regulations for us to check for you. You need to do that homework. Okay? Team member exit agreement will be the last one we go over here. Because some of you are with teams. And is your team lead your broker? Most cases, no. It's kind of like subleasing. You know what I mean? Like I have a rental property and then my tenant decides they're going to get a tenant. So I don't necessarily want to get involved in that. And as a broker, I hate getting involved in that crap. To be blunt. Sorry. I hate getting involved in that. Because it's like you don't want to start splitting the stuff and getting in the middle of people's agreements. And I'm taking off another agent. It's like, look, if D works with Yvette and Yvette's the team lead, and I'm the broker, that agreement's between D and Yvette. You guys handle that. And that's what this says. It says, what is the termination of our agreement? Meaning the team lead and the team member. And most people are on teams. If you're with some of the cloud brokerages or whatever, you're on a team inadvertently. There's a lot of things that get tricky in here. And so basically CAR and DRE and all that are like, hey, we're not touching this, but you guys should have some contractual agreements between you. And this is how we exit. It says we're going to exit. It's mutual agreement, written notice, licensing. What's the cause? Is it a broker affiliation thing? Compensation. What's going to happen with your pending transactions? What's going to happen with any future transactions that started with us? What are the other terms? What do you do with team name? What do you do with anything that comes in and what are you going to be paid out? And that's what it really comes down to. It's like, look, we've got these different items we need to address. So let's have a conversation. Well, I don't have a contract. You work with contracts every day. Go do them with your team lead. Okay. Well, I don't feel comfortable with my team lead. Go find a new brokerage. That's what I say to that. If you can't speak to your team lead, you need a new team lead. So go do that. and I will go to town on that one. Broker, nothing in this exit agreement shall alter the TL or team member's independent relationship or status with the broker if such relationship status continues, which basically says, because this is another reason for it. As a broker, I had this where I had team members of a specific team that they wanted off that team, but they didn't want to leave the brokerage. I was like, cool, come on over. And when they did, I had to hear it from a team leader. Why'd you take my people? I go, we didn't take anyone. They were always part of our brokerage. Why should we lose them because they don't want to work on your team with you? That's between you guys. Okay, but we have an agent that wants to stay affiliated with this organization. So they're allowed to do that. So, but it makes it cleaner. So we're very clear. The brokers have nothing to do with this. This is your guys' thing. You choose to work with each other. You choose to work with each other, but we're still running our business here. We're not getting, well, I got enough family drama. I don't need your drama too. So future transactions with team clients, as we went over. Here is, if you are curious about it, these are the link, or this is the link for it. I will go ahead and put this in the chat for you guys, or you just go in car.org, and I'll just do that because it's not letting me do it. Just go into car.org. It's under documents and transactions. They have all these things. This is your quick guide. It shows all the form changes, some that are major, some that are minor, what was removed. You can also find all sorts of red line versions. All of these are live right now. So, but it just helps you understand a little better and know, what you can research and check. If you're confused about a form, don't just randomly do it. You can always call Car Legal. If you're a broker, there's a designated broker line. You can always call your own broker or team lead or mentor or whatever it is. And it really comes down to, you can always reach out to me or anyone who's here on education, because that's what we do.